Good morning to Mr. Lai and our viewers at home. This will be our presentation for the Semester 4 criminal assignment on the Sexual Offences Against Children Act 2017, which for the purposes of this video, we will shorten into the term SOACA 2017. These are my group members, and this is the assignment question accompanied by the code given to us. This will be how we will structure our. This is the second part of the code given by Marianne Clark, which is subtly hinting at the fact that as important as the written law is, administration, efficient and proper administration is equally important, which is an issue which we will mention in Malaysia. Now, this is a brief background on how the SOACA came to be, and followed by a video by Rach, which points out the 9 things that everyone should know with regards to the new SOACA Act. And although some of these are pretty straightforward, a few of these were more important provisions will be taken out and examined later on by me and Rainy. Now Rainy will deal with this portion of the presentation.
Many legislation such as Penal Code, Child Act 2001 and other complementary legislations seek to protect children against sexual offences in Malaysia. Now I will lay out what is the link between SOACA 2017 and the existing law or statute in Malaysia. With regards to SOACA, Part 2 of the Act deals with offences relating to child pornography, and is supplemented by Section 292 of the Penal Code, as well as the other existing law in the third column, as shown in the third column, which govern all types of pornography under the category of obscene, indecent, and offensive material. This law will illustrate that how the other legislation will complement the SOACA. For example, in 2013, Fila Shahida Zulkifli was charged under Section 292 of the Penal Code by the Muka Magistrate Court. She pleaded guilty of an obscene video of a 15-year-old girl using her mobile phone. She was fined for producing the obscene video. And also in the case of Tan Jin Yi, the appellant has been charged under Section 5, Subsection 1 of the Firm Censorship 2002 for obscene publication in their Tumblr. This charge is yet to be materialized since he has escaped to other jurisdictions. What is to be concluded is that Malaysia regards all pornography as illegal. However, there is no specific law that criminalizing child pornography. With the new SOACA, the law criminalizes possession and production of online child pornography in Malaysia. In terms of sexual assault, in SOACA, Part 4 of the Act will deal with offences relating to sexual assault, while Section 14 deals with physical sexual assault without sexual intercourse, and Section 15 deals with non-physical assault on a child. It is supplemented by Section 354 and Section 377CA of the Penal Code, as well as Section 31 of the Child 2001 deal with sexual abuse of a child. What is to be concluded is that a person charged under SOACA will also be charged under other legislation as well. Therefore, offender could be charged under many counts with regarding to different legislation. Section 376A of the Penal Code deal with incest with a special relationship of trust, however, is very limited. So with regards to Section 16 of the SOACA, it's expected that the type of relationship of trust, including teacher, lecturers, and doctor. The provision in the SOACA 2017 itself seems to be complements to other legislations in Malaysia. So what is next? I will deal with what is so great about SOACA. Firstly, the law related to child grooming. This covers pedophilia. This also can happen over the internet with the pedophile arranged to meet the child in person or on friendship escalating into pornography or sex trafficking. Secondly, with regards to child evidence allows re-examination and cross-examination of child oral evidence. The child evidence allows credibility and more admissibility of child testimonial. So, what is the previous stand before the SOACA? An Existing Evidence Act 1950 provision barring the conviction based on child uncorroborated evidence not given on oath. But now, with the SOACA, the Act allows the child uncorroborated evidence, even when it is not under oath, to be admissible evidence if it is determined that the child has sufficient intelligence and understand the duty of speaking out the truth. Thirdly, is about extraterritorial applications under Section 3 of the Act. What is meant by extraterritorial application? It is said to be if the offence is committed by a Malaysian citizen against a child in any place outside Malaysia, he may be dealt with in respect of such offences as if the offences was committed at any place within Malaysia. For instance, Malaysian citizen commit the offence other place other than Malaysia. When the perpetrator back to Malaysia, he still may be liable to such offences, even though some prosecution had been done in that specific country. Fourth, with regards to the person in a relationship of trust, in SOACA itself, Section 17, subsection 1 and subsection 2, cover individuals who have parental or adult responsibility for a child or children in his or her care. As the sad reality is always that in most of the sexual offences cases, the perpetrator is known to the victim. This provision may further deter those in a position of trust from abusing their position and relationship to the child in committing such offences. To sum up, Sexual Offences Against Children Act covers certain sexual offences against children and their punishment in other written law, and in relation to it to provide for the administration of justice for children and covered matters. The Act tackles many forms of sexual abuse against children. More internet-connected children in the country are vulnerable to new forms of abuse and threat, such as cyber-sexual exploitation. Any communication with intention to meet a child or sexual intent, as long as there is communication, is suffices to be a crime. Further, Malaysia assisted the optional protocol to the CRC on the sale of children, child prostitution, and child pornography in April 2002. This SOACA brings Malaysia closer into alignment with existing international legal framework, such as the Convention on the Rights of Children, CRC.
Now we'll be dealing with the bad of the SOACA. Now primarily focusing on Section 15. Now Section 15 deals with non-physical sexual assault of a child. And the problem is that the Act in itself and also within this section does not deal with the problem of child sex offenders, which unlike Section 13 of the UK Act, states that child offenders charged under the Act are actually given a less harsh sentence with regards to commission of an offence under Section 9 to Section 12. However, it is not mentioned and there is no reference to child offenders anywhere in the SOACA 2017, which is an issue. And it was an issue later only clarified with further research. Upon clarification with the Attorney General Chambers of child sexual abuse and domestic issues, only was it discovered that child offenders will actually be charged under this Act, but meted out with a punishment under the Child Act, which is something that should be mentioned in the Act for further clarity and also understanding of the Act. And also Section 15C deals with non-physical sexual assault on a child, especially when others engage in an activity that is sexual in nature in the presence of a child. Now the main issue is with regards to parents. Now the whole point of being in a marriage is that though couples in a marriage are free to engage in sexual intercourse or sexual activities at their own whims whenever they want, without judgment from society or any other forms of constrictions. Now, say a couple is engaging in these sorts of activities and a child wakes up at night for, let's say, a drink of water, it would be completely absurd for these parents who are just doing what parents tend to do, to be charged for having sex without in the presence of their child, and especially if there is no mens rea, which is the intent to derive any form of external sexual pleasure from the act of being watched, which is a completely different issue. Now, these are several legal loopholes and administrative challenges which are also prevalent, which is the conflict between civil law and Sharia law. And although the issue between civil law and Sharia law has not reached any form of consistency or uniformity, especially with regards to child marriage, that is a big issue because that is the main concern within SOACA, which is that although there is a wide range of protection for children nowadays, there is still no protection with regards to child marriage, which provides a backdoor for child predators to escape as long as they can coerce the family into allowing their child into marriage. And on the other side, you have police supervision, because police are tough and hard. They are trained to deal with criminals, but not so much so victims. And children have to be dealt with very carefully. And the fact that police do not have special training and that special authorities are not brought in to deal with these child victims is another issue administratively. Now here is a slide relating to the previous issue. And another problem is the inconsistent age. Now previously, under the Penal Code, the age of consent was 16. Now under the SOACA, the legal age is 18. This is a 2-year gap in consensual activity. The primary issue is between consensual couples, because for as long as we can remember, the age of consent to sexual intercourse is 16. Raising it suddenly by 2 years is quite a large jump, which may overnight turn couples in consensual relationships, although they are below 18, for example between the ages of 16 to 18, you can turn the male partner of a consensual relationship into a criminal overnight, which is something we do not want, which is something that NGOs have advocated. The government should come up with what they term a sweetheart provision, or also the Romeo and Juliet provision, which is that in cases of consensual relationships, gaps between the ages of 1 to 5 should not be charged with imprisonment or whipping, but instead perhaps counselling, because it is accepted that children between the ages of 16 to 20 commonly engage in sexual activity, in sexual discovery, and it is something that society has grown to accept and understand. And doing so, increasing the legal age to 18 is in a way taking a step back, especially with regards to sexual maturity and sexual understanding in our current society. Now on the other side, we have lack of effective enforcement or aid, which will be, for example, legal aid, because it will be difficult for children themselves to access legal aid, and parents might not want the attention or perhaps the bad light that it shines on them if parents themselves go to seek legal help. And this would mean a lack of legal representation or awareness on these issues, and this is something that the government also has to deal with. And at the end of the day, justice delayed is justice denied. There are still many pending cases which have not been dealt with, and can be if the special court which has been established but now only prevails in Wilayah and also Selangor, were able to expand. Now, with regards to child prostitution, although prostitution in general is illegal in Malaysia, but it is recognized that Asia is actually a hub for child prostitution and child trafficking, and it's something which, as we feel and we submit, have to be dealt with more seriously by the government by including it also in the SOACA. And the issue of consent is another issue which the Act is silent on, and is especially important with regards to the sweetheart defense. Although there is rehabilitative counselling under Section 26 for the perpetrator, placing it under the minister in charge of the prison might not be the smartest move, because they lack specialization and also the time necessary to look into these criminals in particular. And now, on the other spectrum, you have a lack of rehabilitative measures for children who suffer psychological harm and are probably worse off than the perpetrator. Overall, Malaysia is making good progress, and we are following the rest of the world in moving towards the protection of children, and the Act is wide and comprehensive. However, at the end of the day, it's still lacking administrative efficiency, which probably will be dealt with in time and understanding as the law continues to develop. With regards to our European cousins in England and Wales, the Sexual Offences Act 2013 deals with child sexual offences under these sections. One thing to point out is that they have a Protection of Children's Act 1978, which is an act specializing on child pornographic material in the form of photographs, which, although might not be necessary for us, is interesting to note, as SOACA does deal with this under visual mediums in the provisions dealing with child pornography. And child prostitution, as mentioned just now, is another issue. And the laws which UK does deal with, but it's not dealt with in the SOACA, and laws on notification are covered under Part 2 of the Act in Sections 80 to 136. Now, we submit is a very good provision to the Act, as it deals with what to do after the conviction. Because right now, the state of the law in SOACA is what happens leading up to the conviction and the punishment immediately after, and rehabilitative measures, but does not go further than that, especially with regards to notification to protect the general public or third parties who would want to know if someone working with their child actually has a history of child sexual offences. And there is also a very good guidance on interviewing victims and witnesses, which will benefit in particular children, teenagers or young adults. Now, the law on notifications is dealt with, as I mentioned previously, under Part 2 of the Sexual Offences Act 2003 UK. However, this is a journal which we have found, and it shines a bit more light on what the provisions concern, especially with regards to sexual harm prevention orders and sexual risk orders. Now, although these two are very similar in the sense that they restrict what the offender can do, they differ in the amount, in a few things, which is one of them, the length of time. With regards to sexual harm prevention orders, these orders generally last for and cannot be less than 5 years. While with regards to sexual risk orders, the length will not be less than 2 years, but it's generally less than the longer 5-year sentence here. Now, sexual harm prevention orders are orders placed on known offenders who actually have been convicted, while sexual risk orders are probably on those who are suspected or have exhibited signs of possible commission of sexual offences. And these orders are both made to protect the general public with the interests of society at heart, and to help possibly deter potential repeats of the same offences. And this, on the other hand, is the guidance on interviewing victims, which is known as the Achieving Best Evidence in Criminal Proceedings. And as we can see here, there is a Part 2 which deals with child witnesses in particular, stretching up to almost 10 pages themselves, which is very comprehensive, and is definitely more comprehensive than what we have in Malaysia. Now, these are several case studies in the UK. Child sex offenders, R&D, and also RNG. In R&D, the child sex offender was charged with a 24-month period probation, which, as we can see, is definitely different from the charges that are included in the SOACA, which do not reference child sex offenders, number one, and number two, almost all of these offences are charged with imprisonment. And on the other hand, RNG is a detention and training order which stretches up to 12 months. And those in a position of trust, in R and Brony, it would be, these are some examples. R and Brony is a dance instructor. R and Philip Parsons, the perpetrator was a female teacher, and in R and MP, the perpetrator was actually the grandfather of the female victim. And with regards to the Protection of Children Act, like I said, although it's not necessary, there have been several convictions under it which show that there is actually a benefit to having a more comprehensive act, which are R and I and also R and K. Now, lastly, with regards to notification and orders, R and Gordon Andrew Neil was a case where the perpetrator actually breached prevention and harm order under here, sexual harm prevention order, and was actually recharged and given further punishment for breaching it. Which, if we do not have that law here, actually encourages the perpetrators to repeat the same mistakes or to place themselves in positions of potential harm to the society once more. Now I'll let Bill deal with the cross-jurisdiction comparisons.
Other jurisdictions. Firstly, we look at our cousin, Singapore. There has been a large backlash against the recent case of an MMA instructor, Joshua Robinson, and his exploitations of two minors and showing a pornographic video to a child. He has been sentenced for 4 years. There has been a backlash that 4 years is not enough. And then the government is planning to table a bill to impose a harsher sentence on child sex offenders. Currently, status quo is protected under the Penal Code and the Women's Charter. The Women's Charter deals mainly with child prostitution, but it only applies to women and girls, as it's supposed to be a charter against discrimination against women. However, the Penal Code is de facto statute to go to the view on child sex offences. And this is the newspaper article from Channel News Asia. See these sections under the Penal Code. It is embedded into the statutory definitions of rape, sexual intercourse, and so forth and so forth. Prison sentence for below 14 and rape below 14 and sexual intercourse below 14 is the same as the adult sentence, which needs to be improved. The extraterritorial principles dealt in Section 3 of the Penal Code, and it has a few weaknesses. Primarily, it is the child porn, child pornography, and there's a debate on the sexual grooming provision being too short. India is a curious jurisdiction that recently passed a bill concerning the sexual penetration of a child other than the penis. Although it has similarities on child porn, child betting, harassment, and things like that, it deals with certain provisions that Malaysia didn't cover, Singapore and neither actually, especially on the issue of gang rape and children rape. The provision that says that if you omit to report a case, if you are part of the media or you actually seen these things happening, or you are in touch with child pornography, you can be jailed up to 6 years rather than the fine in Malaysia. And of course, this penetrative, non-penetrative, and aggravated sexual assault, gang rape, as I just said, and yes, liberalized how a child's testimony can be taken. They're recording, they give more breaks to children, not testify so much, which is a relatively good progressive attitude to the child as compared to other jurisdictions. But relatively, Malaysia has that too. Why is it so bad? It's rather specific. That's the issue of police officers being in the position of trust. Yes, of course, police officers should have a larger duty of care to children and not exploit them. But in targeting police officers specifically, it didn't really target the other special positions of trust, especially using parents or teachers and coaches and so on and so forth. And the provision of prostitution is rather ambiguous. That the title mentioned that one of the purposes of enacting this act is to curb prostitution, but it was never stated in the act itself. And what is really disturbing, this act is, although it is progressive in its time and it's rather one more comprehensive statutes out there, however, this has a weak implementation. Now we're going to Australia. Australia has a different culture, as it's more liberal. That's the controversy. The controversy here is on as minors can have what is the age of consent to sex. there's a larger debate in that. However, in terms of this de facto status quo, what we have here is that the child pornography was dealt with to 2004 itself. 2013 is dealing with a young person in special care, but so far so good. But the provisions were scattered all over the place because it's a federal, it's a federal government and it practices federalism. But it's relatively inaccessible and complex. One of the issues in Australia is its implementation. No compulsory jail time for sex offenders. That the Parliament is trying to table a bill, and there's still very high sex abuse rates. Although it can be said that these figures are public and they are lesser child crime as well, because of the big exposition on the media, but this is still the truth that is still relatively high, as seen in this case. One of the biggest controversies in later years is the controversy with Cardinal George Pell, for instance. The Cardinal George Pell, a Catholic priest, was charged for sexual assault against children and so forth and so forth. And this was a big deal that shows how the Australian legislation is not entirely enforced in these crimes. This is the master chart. It highlights different legislations in different jurisdictions in regards to the issue. It is primarily based on Malaysian provision, but yeah, it applies what the other states fail to match up in Malaysia. The green ones are covered in the Act, the red ones aren't, and the blue ones are covered in this Act ambiguously, or not completely, or in another Act completely or uncompletely. This Malaysia usually gets almost everything green, except on child gang rape, that's a specialty of India. And you see how other jurisdictions have a few gaps between. So in Malaysia fairly matches up quite well. You see how Singapore does not address these issues, and how England, Wales, Malaysia, and some parts of Australia do actually cover these issues. Singapore has the blue extraterritorial application because it does not deal directly with child pornography and sexual abuse. Where does Malaysia stand? It is progressive, it is well thought of, and it is quite successful as compared to other jurisdictions. It is accessible as compared to Australia, it is relatively better in enforcement as compared to India, and is relevant to the current situations. It's born out of the various crimes that are taking. Does Malaysia stand in comparison to other legislations? Well, the SOACA is quite progressive at this time, that it is making good progress and is relevant to the situation. 14 cases were tried so far in this Act, which means it is better in its enforcement as compared to previous legislations. It is accessible, and it gives fair rights to the child, which is a basic human right. And of course, it deals with many areas, child grooming. However, as compared to the other countries, Singapore actually lacks some provisions in Malaysia, primarily the low prison sentence. India, however, is quite, although it's quite comprehensive, it is also overly specific and does not cover the areas that it's supposed to cover, and is bad in its enforcement. Australia is, since it's a federal government, since we practice federalism, despite that, it's still incoherent because in its federal territory and federal state, and it needs enforcement. In the UK, I would rank similarly with Malaysia in terms of their various provisions and their various protections to the child. Although both can be improved by looking at each other. So relatively, Malaysia relatively is quite comprehensive, and compared to other jurisdictions, it is much better. In crux, nutshell, we have seen how the bad is the good. Without the cases regarding Richard Huckle or the Kelantan man who was charged with 499 cases of sodomy to his daughter, without these cases, we will not have the SOACA. So we can see how the good comes from bad most of the time. Therefore, we urge the progressive nature of the law to progress and to reform constantly, so that our country will be a better state and federation. Thank you.